A Civil War legislation called the False Claims Act has been on the books since that period of time. In 1986, I believe it was, I got some amendments to it that it made it a much more valuable piece of legislation than it was before that time. It's called the False Claims Act, and it's brought, I think, something like $64 billion back into the federal treasury of fraudulent taken money since then. The problem today, even though it's been a successful law, is that the courts tend to, from time to time, neuter its capabilities by interpreting it in a way so it's not quite as effective. From time to time, we have passed legislation to overcome some of those court decisions. So I'm here today to talk about another opportunity this Senate has to make the False Claims Act the effective piece of legislation it was. So I want to alert my colleagues about the most recent limitations the courts have imposed on the False Claims Act. The False Claims Act was signed into law by President Abraham Lincoln in 1863 for the very same purpose it serves today, to fight fraud, not just with military matters, as was the reason for doing it, because the Union Army was being defrauded at that particular time, but today it fights fraud government-wide. Today, it is the government's most powerful anti-fraud statute. That's because amendments that I offered in 1986 empowered whistleblowers to sue fraudsters on the government's behalf with or without the government's help. Since then, we've recovered more than $64 billion of taxpayers' money lost to fraud. Now, when we talk about anti-fraud statutes like the False Claims Act, we use the term materiality. And it's that term that the courts have caused, their interpretation of that term has caused the act to be less effective. The False Claims Act defines materiality as, quote, having a natural tendency to influence or be capable of influencing the payment or receipt of money or property, end of quote. Basically, if the government could have withheld payment, then it was likely material. However, based on a 2016 Supreme Court opinion, the federal courts are trying to reshape the Act's materiality requirement. In the Supreme Court opinion, Escobar, I quote, if the government pays a particular claim in full despite its actual knowledge that certain requirements were violated, that is very strong evidence that those requirements are not material, end of quote. Citing this language, other courts have made the government's payment decisions in these cases a deciding factor. Consequently, the Justice Department now shies away from prosecuting these cases. That's the case even when the fraud is very obvious and then obviously material. Recently, the Office of Special Inspector General for the Afghan Reconstruction briefed me on a report about a botched Defense Department effort to quickly buy cargo planes from an Italian manufacturer called Alenia. In 2009, the Department of Defense bought 20 cargo planes from this company, Alenia, for $549 million. These planes were intended to move and train Afghan pilots. This is the type of plane we're talking about. The contract required the manufacturers to refurbish 20 retired aircraft and provide enough spare parts for 10 years of maintenance. To seal the deal, the company even took Department of Defense personnel on several warehouse tours to prove they had all these spare parts. When the planes arrived in Afghanistan, mechanics quickly noted the planes were very poorly refurbished. Worse, they couldn't actually fly. The poor state of the planes and the hazards of the Afghan elements made that impossible. The company, Alenia, also lied about their maintenance commitments. Now remember, I already told you their promise. Those warehouses were full of parts for the next 10 years. These spare parts that they showed them were not for these planes. In other words, they were for the wrong planes. Despite this blatant fraud, Department of Defense inspectors kept certifying the planes, and the government kept making payments. But here's the catch. The inspectors later admitted that many of the documents and manuals they reviewed were in Italian, and none of them spoke Italian. The final count, out of 20 aircraft, 4 never even made it to Afghanistan. It's unclear why the Department of Defense continued making payments despite these flagrant violations. But by 2013, it became clear that continuing these programs was unfeasible, and the government tried to sell the remaining 16 planes. Well, you can imagine, nobody wanted these planes. So the Obama-Biden administration sold them all for scrap metal. You can see the scrap metal right here. So to recap, the government bought 20 airplanes for $549 million, and in less than 5 years sold them for $40,257 worth of scrap metal. The photos next to me show what we bought compared to what it was actually worth, a literal pile of garbage. It's clear that the actual condition of planes and lack of parts were very material components of this contract. So see that word material. Now, thanks to the Department of Defense's poor judgment and also the court's new standard on materiality, the Justice Department won't bring False Claims Act charges against that company. Materiality is important to protect against parasitic lawsuits, but we can't allow defendants to get away with, can't let defendants get away with scalping the taxpayers because some government bureaucrats failed to do their jobs. Government bureaucrats are highly segmented and often unable to make key decisions for their organizations. Now, that's not the employee's fault. That's just kind of the way government, I'm sorry to say, operates. Also, the government also typically stops payments only when it has fully investigated and corroborated a claim of fraud. And in my many years of investigating the Department of Defense, it has taught me that a Pentagon bureaucrat is rarely motivated to recognize fraud. That's because the money doesn't come out of their pocket. This example highlights how the court's narrow interpretation of materiality fails to take into account how the government really works and why we need to overcome the court's decision on definition of materiality. When the False Claims Act was originally passed, one fraudster boasted, and this is a direct quote, "You can sell anything to the government at almost any price if you got the guts to ask," end of quote. Unfortunately, that was true in this case as well. I have already made it public that I'm working to patch this hole in the taxpayer's pocket. This example perfectly illustrates the need for change. I'm working on introducing legislation to address the issue, and I'm in the final stages of negotiating and look forward to putting forward a bipartisan bill in the coming weeks. I suggest the absence of a quorum.
Clerk will call the roll.